think the telling part of that is about the employment statistics. I think that we're suffering really badly in the employment statistics, but it's not showing up, and that's I think the area that's being revealed that racial discrimination is a factor.
Can I ask you this, tying that to the Race Discrimination Act, you've acknowledged that the Racial Discrimination Act has been effective in addressing outright prejudice against people on the ground of their race or Indigenous peoples, but we still have the reservation in relation to CERD for criminalising racial vilification. We do have our own special view of special measures, which could be adverse measures, doesn't seem to trouble us. What's your assessment of the utility of the RDA as an instrument to address Indigenous disadvantage, or are you in fact speaking about a whole range of measures that leave the RDA behind or to one side?
I think the messaging I'm coming up with is that the RDA now has to be reviewed, and besides just having an instrument which reflects the responsibilities under the Convention, which it does do apart from racial vilification, I think it's also got to build into there something more of strategy and program. That's got to be part of it. You can't just have an act. One of the things I've skipped past is the fact that Aboriginal people are not using the RDA in relation to complaints. That if you look at statistics of the Australian Human Rights Commission, I'm not sure about state by state, Aboriginal people are the least users of the Racial Discrimination Act, even though we're most likely to be the highest victims under it. So I'm really going along the lines that I think equality legislation probably needs to provide more objectives and more strategic purpose as to what it's setting out to achieve, not just rely upon providing us with process. And I dug down deep in that presentation to say that these are rights, for example, our land, our right to resources, including the minerals, our rights to development, are part of this whole process, but Australia is not yet ready for coming to grips with these sorts of issues. So again, this is something that's got to be, I think, addressed in equality. If we're talking about general equality legislation, the position of Aboriginal and Torres Strait Islander people as peoples within the nation of Australia has to be addressed.
I suspect that's a theme that we're going to keep coming back to, and Carol on a panel I was on this morning mentioned is that the gap between the promise of legislation and what it delivers. And I hear part of what Liz is saying is a gap between what the RDA is assumed to promise and what it can achieve, both because it's perhaps not being used enough, but because quite simply just doesn't go far enough. Well, that's it. And that may be true of other grounds. Any other comments or questions before we move on? Yes? Hang on, I've got one, and then one at the back, and then one down the front.
Les, Chris Graham's wrote extensively on the myths that the Northern Territory intervention were based on, and one of the, by the Howard government, when it was introduced. What do you think of the work from Chris Graham in terms of exposing those myths that the intervention was based on?
Look, I think Chris did an excellent job in relation to Mutijulu about what was going on there. As we know, those things are now, evidence is there to show that they were fabricated. The government was implicit in the fabrication of it all. But I think at the moment, our main objective is to try and end the intervention based upon that fabrication and get down to some real improvements in those communities and empowerment of those communities. So it's not the case of not looking back, but I will point out there that as far as I know, the people that have been subject to that intervention for the last 40 years will not have a right of compensation, which is one of the provisions that is provided to victims of racial discrimination. There won't be a remedy for compensation for discrimination that they've suffered. So I'll just leave it at that comment, but I think that Chris did good work on Mutijulu.
Man up front here and man at the back.
I'm just curious if the Racial Discrimination Act, so I don't have knowledge of it, has the same provision, or they have the same inability to, for a client or a person trying to make an action to go through to the federal court. Is that cost barrier a significant issue for the Racial Discrimination Act as it is with the Disability Discrimination Act? And coming on from that, if it is or isn't, what are the legislative barriers to the Racial Discrimination Act as they are being used by the clientele?
The questions was about the cost barrier in racial discrimination legislation and any other barriers to people using it.
Of course it's a real barrier, and it's a pity because I think it was the issue of racial discrimination that was in the Brandy case, Brandy versus Bell or whatever it was, that led to the ruling that tribunals couldn't adjudicate and sent these issues to the federal court, took the commission out of the process. And just dealing in that area, my view is that the role of the Australian Human Rights Commission as a friend of the court in the federal courts perhaps can be strengthened even more at the moment. I think they have to get permission from the Attorney General to take part in that and do it. My organisation, Foundation for Aboriginal Island Research Action, has been heavily involved in legal cases. In fact, we won about $60 million in compensation to people who didn't get award wages in Queensland through that. But other cases we want to take on, we were deterred by the cost. We were basically saying if we took this on and cost rewarded against us, it would basically bankrupt the organisation, so we couldn't do it. So cost is a big factor about all this, and I think that that's the same for individuals who want to take the matter on. However, I think also we shouldn't discount how much arbitration can resolve a lot of the issues. I think generally in the overt discrimination areas, people will back down if racial discrimination is the matter there. But as I said, we've also got a problem with deeply entrenched racial discrimination as well.
We'll take one more and then we'll go on to Phillip. Well, this microphone that's going around, it's one of these entertainment microphones. We actually put it right in front of your lips, don't be shy. That's how it works. If it's out here, we won't hear.
Karaoke. Yeah. Just on the same theme, really, access to justice, I suppose, or barriers to access is the other one. I think it's not just the Indigenous people wanting to make claims, but anyone in this area is lack of access to legal representation because there's inadequate funding or there's just not enough pro bono support to go around. I mean, in the end, it's we've already said all day about how complex the legislation is. Hard enough for lawyers to work with it, let alone clients that want to make a complaint. We're really needing legal representation. So organisations like Aboriginal Legal Service, Legal Aid and Community Legal Service need to be appropriately funded so that people can be represented.
Yes. Yep. This is not it. Okay. We'll have more time later, but we'll go to Phillip French and disability. Yeah, we've got a microphone.
Thanks very much. I've just got a few points that I'd like to make, basically in 6 areas, speaking from a disability rights perspective. And in preparing these comments, I'm sure other speakers had the same feeling. It's difficult to know where to pitch comments, whether we're pitching them to a consolidation project and marginal opportunities for improvement, or whether we're pitching them to a reform agenda that might be pursued by the community sector that might give us the sorts of laws in Australia that we really would like. So I'm going to bounce a bit between those two things. In terms of one of the big things one hopes comes out of the consolidation project is a much more positive vision about what equality is and what it means to individuals and to our communities. Discrimination legislation in Australia is framed in the negative. It's about conduct that is prohibited, and I think there should be much greater emphasis on what it is we're actually trying to achieve. Not only because I think that has an important educative function, but as I'll talk about later, I think that's also very important in giving the courts guidance in relation to the damage, the personal harm that is caused by discrimination, and why they ought to be persuaded perhaps to award more damages in particular cases than they do. I'll come back to that point in a minute. In terms of the consolidation, from a disability perspective, we're hopeful that will result in a rounding up of the definition of discrimination to one that is equivalent to the Racial Discrimination Act. The disability discrimination definitions are pretty mean-spirited. There's been a bit of an effort to improve them over time, but basically they're pretty mean and the courts apply them in a very mean way. It would be better that we work from a Racial Discrimination Act model, which is paralleled in the Disability Convention with some important additional clauses, which I won't have time to go into, but it seems to me that that would be a good thing to do at the level of definition. If we can't go that far, then at the very least I think we should be aiming for a net detriment test for discrimination rather than the comparator test.